On March 6, 1857, a decision by the Supreme Court of the United States was reached in the case of Scott versus Sanford, set off a chain of events that helped lead to the Civil War. Here are the judgments regarding that verdict.
Dred Scott. I was born in Virginia and lived there till I was 18 years old. My master was Peter Blow. When I was about 18 or so, I think, we moved to Alabama. And then, when I was just about reaching my 30th birthday, we moved again to St. Louis, Missouri. Some 2 years after that, Master Blow died. The year after, Dr. Emerson, a surgeon in the Army, died, and I remained under his service for the next 3 years. He served as the doctor at Fort Armstrong in Illinois. We lived at the fort. I'm telling you all this because it's my story and it's what I know. They tells me I could have asked for my freedom after being in Illinois a couple of years, but I didn't know that at the time. You see, we colors were never taught how to read and write. So there's a lot of things that we just don't know. Now, Illinois was a free state, but it was also a frontier state. And I lived in a fort along the Mississippi, which was just about the edge of what was known as the United States. Beyond that was pretty much Indian territory. Freedom for a black man in Indian territory don't make no sense. Besides, Dr. Emerson, like Master Blow himself, had done me fairly, and I didn't see no reason to run. There was one more thing to get my freedom. I'd have needed a lawyer. There was lawyers willing to work with folks like me for free as members of what they call activist groups. But I didn't know about them at the time. After I'd been with the doc and the fort for a few years, the Army evacuated the place, and the doc and I headed out to Fort Snelling, what was then called Wisconsin Territory, and they're now named Minnesota. Now, once you cross the Mississippi, slavery is against the law, and I was automatically free. But nobody told me, and I don't think anybody at the fort even knew. While I was at Fort Snelling, I met me a girl named Harriet Robinson, and soon after we got ourselves married. Now, she was owned by a fellow named Major Lawrence Taliaferro, and he was the Indian agent. He was also the Justice of the Peace and performed the marriage ceremony. In October, the following year, the doc, my master, left for Jefferson Barracks back in St. Louis. He left us at Fort Snelling, where he rented us out to other people. In November, the doc was sent to Fort Jessup in Louisiana. And there, he met and married a guy named Eliza Irene Sanford. And in spring, the doc asked Harriet and me to join him. So Harriet and me went down to the Mississippi unaccompanied until we met my master and his new wife. But then, before the year was out, we were transferred back to Fort Snelling. On the way, my wife gave birth to our first child. On the steamboat upriver, a daughter named Eliza. A couple of years later, the doc was sent to Florida to serve in the Seminole War. He left us with his wife in St. Louis. When we came back, he only stayed with us a little while before he had to move on to Iowa, while we stayed in St. Louis, hired out to various people. Then, Doc Emerson died, and we were the property of his wife, Irene Emerson. But we had little to do with her, and we were also rented out to other folks. Once the doc was dead, I realized there was nothing else hanging on to us, and that we could acquire our freedom. By then, I had found out some of the law going on and decided to make a claim to get me and my family free. So the lawyer, he sued Miss Irene for our freedom, but we lost because he said no witness could prove she owned title to us. So the lawyer challenged the ruling and was delayed until January of 1850. So the jury says I and my Harriet is free. Then Miss Irene called for an appeal. Meanwhile, she moved to Springfield, Massachusetts to marry a Dr. Calvin Chaffet. So since she in another state, she turned the case over to her brother, Mr. F.A. Sanford. Now in 1852, the Missouri Supreme Court says we still slaves. Our lawyer gets real mad, says the judge overturned decades of law precedent to make sure Missouri stay a slave state. So he take it to the U.S. Circuit Court. Now I have a new bunch of lawyers on the case who is abolitionists, and they sue Mr. F.A. Sanford, who is in New York, but is acting on a case in Missouri. So now the case go to a Washington to decide a Missouri case again, a New York public businessman working on behalf of a Massachusetts woman. One of them lawyers is a Mr. Charles Edmund LeBoom, a brother-in-law to one of Peter Blow's sons, and my old master. He sued Mr. Sanford for battery and wrongful imprisonment. First, they had to decide whether I had the right to sue based on whether or not I was a slave or I was an American citizen. If I was not a citizen, I may not have the right. They finally decided, slave or not, I had the right to sue. So we sued Mr. Sanford, but he remained slaves under the law. So we were given over to the federal Supreme Court. It wasn't until 1856 that they decided to hear our case. But first, they have to hear arguments on the Missouri Compromise. Then they say the case is getting too near to an election and is likely getting a little too political. Finally, we go ahead anyway and hear the case. And all me and my Harriet can do is wait for the results.
Roger Brookie Taney, Maryland. Decision rendered March the 6th, 1857. The issue before the court are that there are two leading questions presented by the record. One, had the Circuit Court of the United States jurisdiction to hear and determine the case between the said parties? And two, if it had jurisdiction, was the judgment given erroneous or not? The plaintiff, Dred Scott, was, with his wife and children, held as slaves by the defendant, F.A. Sanford, in the state of Missouri. And he brought this action to the U.S. Circuit Court for Missouri. The declaration is that he and the defendant are citizens of different states, that he is a citizen of Missouri and the defendant a citizen of New York. If the question raised by the plea in abatement is that the court should be of the opinion that the facts disqualify the plaintiff from becoming a citizen, then the judgment of the Circuit Court on the plea in abatement is erroneous and must be reversed. However, if that plea is not before us, and the judgment in the court below on this plea was in favor of the plaintiff, he does not seek to reverse it, we believe the plea in abatement is under consideration. And therefore, it is our duty to decide on constitutional rights in the case. The question is this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community brought into existence by the Constitution, and as such is entitled to all the rights, privileges, and immunities guaranteed by that instrument to each citizen. One right being the privilege of suing in the courts of the United States. And the question before us is whether the class of persons described in the plea in abatement, being people of African ancestry, are our fellow constituent members of this sovereignty. We think they are not, and that they are not included, and were not intended to be included under the word citizen in the Constitution, and can therefore claim no rights and privileges provided for citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges under those who held the power, however the government might choose to grant them. It is not the province of the court to decide upon the justice or injustice as to the policy of these laws. The decision belongs to those who formed the sovereignty and framed the Constitution. The duty of the courts is to interpret what they have framed and administer it as we find it, according to the true intent and meaning when it was adopted. We must not confound the rights of citizenship, which a state may confer within its own limits, and the rights of citizenship as a member of the Union. Does not by any means follow, because he has the rights and privileges of a citizen of a state, that he must be a citizen of the United States. He may have all the rights and privileges of a citizen of a state, and yet not be entitled to the rights and privileges of a citizen in any other state. Previous to the adoption of the federal Constitution, every state had the right to confer on whomever it pleased the character of citizenship and endow him with all its rights. But this character was confined to the boundaries of that state and gave him no rights or privileges in other states. Nor have the several states rendered their power of conferring these rights by adopting the Constitution of the United States. Each state may still confer upon them a degree of alien upon any such person. He would not be a citizen as defined or entitled to sue in one of its courts, nor to any privileges in any other state. The rights which he would acquire would be restricted to the state which gave them. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, which is exclusive. Consequently, no state, since the adoption of the Constitution, can be neutralizing an alien invested in him with the rights secured to citizenship under the federal government. Although, so far as that state was concerned, he would undoubtedly be entitled to citizen rights for that state alone. Therefore, that no state can, by any act or law of its own, induce a new member into the political community created by the federal government. No state can make him a member of the United States by making him a member of its own. Whether the provisions of the Constitution Constitution allow rights and privileges to the Negro, African race, made free in any state, and put in power of a single state the ability to make him a citizen of the United States, and endow him with the rights of citizenship in every other state without their consent? Does the Constitution immediately clothe him with all the privileges of citizenship in every other state? Should one state say so and apply such in all courts? Blacks have no rights. The court believes these propositions cannot be maintained. If it cannot, Dred Scott could not be a citizen of the state of Missouri, and consequently was not entitled to sue in its courts. Now, it is true, every class and description of persons who were recognized as citizens in their own state at the time of the adoption of the Constitution immediately became citizens of the new political body. But it was created for them and for no one else. Personal rights are guaranteed to citizens of this new sovereignty and were intended to embrace those only who members of the states and those afterward by birth or otherwise according to the provisions of the Constitution. And it becomes necessary to determine who were citizens of the states when the Constitution was adopted. The legislation and histories of the times and the language used in their Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether free or not, were intended to be included. Now, it is difficult at this day to realize the state of public opinion in relation to that unfortunate race. They had for more than a century before been regarded as being of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro must justly and lawfully be reduced to slavery. He was bought and sold and treated as an article of merchandise and traffic wherein a profit could be made by it. The opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing. And men in every grade and position in society daily acted upon it in their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of this opinion. And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world. The opinion thus entertained and acted upon in England was naturally impressed upon the colonies they founded on this side of the Atlantic. Accordingly, a Negro of the African race was regarded by them as an article of property, held, bought, sold as such. And every one of the 13 colonies which united under the Declaration of Independence, afterwards in the Constitution, slaves were more or less numerous in the different colonies, as slave labor was more or less profitable. But no one seemed to have doubted the correctness of the prevailing opinion at the time. In Maryland, 1717, a law was passed declaring any free Negro or mulatto intermarried with any white person, said Negro or mulatto shall become a slave during life, excepting mulattoes born of white women, who for such intermarriage shall only be servants for 7 years. Now, in Massachusetts, in 1705, a law was passed to prevent spurious and mixed issues. Should any Negro or mulatto, free or not, strike any person of the English or other Christian nations, such Negro or mulatto shall be severely whipped. The laws show the degraded condition, even if misunderstood, of this unhappy race, and were still in force when the Revolution began. They are an index of feelings towards the race and of the position they occupy throughout the 13 colonies in the eyes of the men who framed and established the state constitutions and governments. They show that a perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery, governing them as subjects in absolute despotic power. Intermarriages between white persons and Negroes were regarded as unnatural, immoral, and punishable as crimes, even to the person who joined them in marriage. No distinction was made between the free Negro and the slave. This stigma was fixed upon the whole race. We refer to this for purposes of showing the fixing opinions concerning that race upon which the men of that day spoke and acted in order to determine whether the terms used in the Constitution was intended to include them or give them or their posterity any of its provisions. Equal rights. The language of the Declaration of Independence is equally conclusive. We hold these truths to be self-evident, that all men are created equal. Governments are instituted deriving their just powers from the consent of the governed. The general words above quoted would seem to embrace the whole human family, and if they were used in this day would be so understood. But it is clear that the enslaved African race was not intended to be included and formed no part of the people who framed this declaration. If the language is understood in that day would embrace them, the conduct of men who framed the declaration would be flagrantly inconsistent with the principles they asserted, and would deservedly so receive universal rebuke and reprobation. Yet, the men who framed this declaration were great men, high in acquirements, high in sense of honor, incapable of asserting principles inconsistent with those on which they were acting. They perfectly understood the meaning of the language they used and how it would be understood by others. And they knew that it would not be in any part of the civilized world be supposed to embrace the Negro race, which by common consent had been excluded from civilized governments and the family of nations and doomed to slavery. They spoke and acted according to the then established doctrines and principles of the day. The black race was separated from the white by indelible marks long before established, and was never thought of except as property, when the claims of owner or trader needed protection. This state of opinion had undergone no change when the Constitution was adopted, and is equally evident from its provisions. Now, two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons and show clearly that they are not regarded as citizens. One clause reserves the right to import slaves until the year 1808. And by the other provision, the states pledged themselves to each other to maintain the right of property of the master by delivering up to him any slave who may have escaped from his service. They show that neither the description of such persons nor their descendants were embraced in any of the other provisions of the Constitution. No one of that race had ever emigrated to the United States voluntarily. All of them had been brought here as articles of merchandise. The number that had been emancipated at that time were but few in comparison with those held in slavery, and they were identified in the public mind with the race to which they belonged and regarded as part of a slave population rather than free. It is obvious that they were not even in the minds of the framers of the Constitution when they were conferring rights and privileges upon the citizens of state and union. It is impossible to believe that rights were intended to be extended to them, given their condition. Now, it is true that in that portion of the Union where the labor of the Negro race was found to be unsuited to the climate and unprofitable to the master, few slaves were held at that time the Constitution was adopted. Measures were taken for gradual abolition in them. But this did not produce any change of opinion in relation to this race. It would be impossible to enumerate the various laws and markings of the condition of this race. No part of the country, except in Maine, did the African race participate equally with whites in civil and political rights. The legislation of the states showed the inferior condition of the race at the time of the Constitution. It is hardly consistent to suppose that they be regarded as fellow citizens. It also cannot be believed that the large slave-holding states would have consented to a constitution which might compel them to receive them as citizens. If the Negro was so received, it would exempt them from the operation of special laws and police regulations which slaveholder states consider to be necessary for their own safety. Persons of that race would have the right to enter every other state whenever they please, without passport or obstruction. This would inevitably produce discontent and insubordination, endangering the peace and the safety of that state. It's impossible to believe that the great men in slave-holding states who took such a large share in framing the Constitution and exercised so much influence in its adoption would have been so regardless of their own safety and the safety of those who trusted in them. Congress had repeatedly legislated upon the same construction, such as the Naturalization Law, March 26, 1790, which confines the right of becoming citizens to aliens being free white persons. Another, in the first militia law, passed in 1792 at the first session of the Second Congress, which directs every free, able-bodied white man, citizen, be enrolled in the militia. The word white is evidently used to exclude the African race, and the word citizen to exclude any naturalized foreigners, the latter forming no part of the sovereignty, owing to no allegiance, and therefore under no obligation to defend it. The African race, however, born in this country, did owe allegiance to the government, whether they were slave or free, but it is reputed and rejected from the duties and obligation of citizenship. A third act is even more decisive, passed as late as 1813, providing that after the termination of the war in which the United States was engaged with Great Britain, it shall be unlawful to employ on board any public or private vessel of the United States any person of color. Upon full and careful consideration of the subject, the court is of the opinion that Dred Scott was not a citizen of Missouri, within the meaning of the United States Constitution, and not entitled as such to sue in its courts. Consequently, the circuit court had no jurisdiction in the case, and that the judgment on the plea in abatement is erroneous. It appears affirmatively on the record that he is not a citizen, and consequently his suit against Sanford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. The suit ought, in this view, to have been dismissed by the circuit court, and its judgment in favor of Sanford is erroneous and must be reversed. We proceed, therefore, to inquire whether the facts relied on by the plaintiff entitled him to his freedom. In considering this part, two questions arise. One, was he, together with his family, free by reason of the stay in the territory of the United States? And if they were not, is he free by reason of his removal to Rock Island in the state of Illinois, as stated? The Missouri Compromise, upon which the plaintiff relies, declares that slavery and involuntary servitude, except as a punishment for crime, shall be forever prohibited in the territory seceded by France under the name of Louisiana. The counsel for the plaintiff has laid much stress upon the article in the Constitution which confers on Congress the power to dispose of and make all needful rules and regulations respecting the territory belonging to the United States. But in the judgment of the court, that provision has no bearing on the present controversy, and the power given was intended to be confined to the territory, at which time that was claimed by the United States, and was within the boundaries as settled by the Treaty of Great Britain, with Great Britain. They had no influence upon the territory afterwards acquired from a foreign government. It was a special provision to meet a present emergency, and nothing more. In the Constitution, when granting the power to legislate over the territory that may be selected for the seat of government independently of the state, it does not say Congress shall have power to make all needful rules and regulations respecting the territory, but it declares Congress shall have power to exercise exclusive legislation in all cases whatsoever over such a district not exceeding 10 miles square. We take the particular clause in question by itself or in connection with the other provisions of the Constitution, we think it clear that it applies only to the particular territory which the new government might afterwards obtain from a foreign nation. Consequently, the power which Congress may lawfully exercise in this territory confront no justification, and to support a similar exercise of power over territory that may afterwards be acquired by the federal government. Did Scott's residence in Illinois affect his status? It is contended on the part of the plaintiff that he is made free by having been taken to Rock Island in the state of Illinois, independently of his residence in the territory of the United States, and being so taken, was made free. And he was not again reduced to a state of slavery by being brought back to Missouri. The principle on which this depends was decided in this court upon the case of Strader versus Graham, 1850. In that case, the slaves having been taken from Kentucky to Ohio with the consent of their owner, and afterwards brought back to Kentucky, this court held that their status as free or slave was dependent upon the laws of Kentucky when they were brought back into that state, and not of Ohio, and that this court had no jurisdiction to revise the judgment of a state court upon its own laws. So in this case, as Scott was a slave and taken into the state of Illinois by his owner, and was there held as such and brought back in that character, his own status as free or slave depended on the laws of Missouri and not of Illinois. Conclusion. On the whole, therefore, it is the judgment of this court that it appears by the record before us that the plaintiff in error is not a citizen of Missouri. And the circuit court, for that reason, has no jurisdiction in the case and could give no judgment in it. Its judgment for the defendant must, consequently, be reversed, and a mandate issued directing the suit to be dismissed for want of justification or jurisdiction. Therefore, under this rule, the plaintiff, Dred Scott, remains a slave. Concurring opinions. Justice James M. Wayne of Georgia. Justice Samuel Nelson of New York. Justice Robert Cooper Greer of Pennsylvania. Justice Peter V. Daniel, Virginia. Justice John Archibald Campbell, Georgia, and Justice John Catron of Pennsylvania.
Justice John McLean, New Jersey. The plea to the jurisdiction is not before us. The decision on the plea in abatement was in favor of the plaintiff, and he does not complain of the decision on it. The defendant might have complained of this decision against him and have prosecuted a writ of error to reverse it, but as the case under the instruction of the court to the jury was decided in his favor, of course he had no ground to complain. The plea which raises the question of jurisdiction is this: that the plaintiff is a Negro of Africa descent, his ancestors being of pure African blood, and were brought into this country and sold as Negro slaves. But this does not show that he is not a citizen of Missouri within the meaning of the Act of Congress authorizing him to sue in the court. It has never been held necessary to constitute a citizen within the Act that he should have the qualification of an elector. Females and minors may sue in the federal courts, and so may any individual who has a permanent domicile in the state under whose laws his rights are protected and to which he owes allegiance. Being born under our Constitution and laws, no naturalization is required as one of the foreign birth to make him a citizen. The most general and appropriate definition of the term citizen is a free man. Being a freeman and having his domicile in a state different from that of the defendant, he is a citizen within the acts of Congress, and the courts of the Union are open to him. In the argument, it is said a colored citizen would not be an agreeable member of society. This is more a matter of taste than of law. Several of the states have admitted persons of color to the right of suffrage, and it is this you have recognized them as citizens, and this has been done in slave as well as free states. In the question of citizenship, it must be admitted we have not been very fastidious. Under the Lee Treaty with Mexico, we have made citizens of all grades, combinations, and colors. The same was done in the admission of Louisiana and Florida. No one has ever doubted, and no court has held, that the people of these territories did not become citizens under the treaty. They have exercised all the rights of citizens without being naturalized under the acts of Congress. On slavery being a state institution, in the formation of the federal Constitution, care was taken to confer no power on the federal government to interfere with this institution in the states. In the provision respecting the slave trade, in fixing the ratio of representation, and providing for the reclamation of fugitives from the labor, slaves are referred to as persons, and in no other respect are they considered in the Constitution. We need not refer to the mercenary spirit which introduced the infamous traffic in slaves to show the degradation of Negro slavery in our country. This system was imposed upon the colonial settlements by the mother country. And it is true to say that the commercial colonies and the states were chiefly engaged in this traffic. But we know that a historical fact that James Madison, a leading member of the Federal Convention, was solicitous to guard the language of the instrument as to not to convey the idea that there could be property of men. In Congress, if Congress should deem slaves or free colored persons injurious to the population of a free territory as introducing to lessen the value of the public lands, or on any other ground connected with public interest, they have the power to prohibit them from becoming settlers in it. Where a territorial government is established in slave territory, it is uniformly remained in that condition until people formed a state constitution. The same course where the territory was free, both parties acting in good faith, and would be attended with satisfactory results. The sovereignty of this federal government extends to the entire limits of our territory. Should any foreign power invade our jurisdictions, it would be repelled. I think the judgment of the courts should be reversed.
Justice Benjamin Robbins Curtis of Massachusetts. The question is whether any person of African descent whose ancestors were sold as slaves in the United States can be citizens of the United States. If any such person can be a citizen, this plaintiff has a right to the judgment of the court. For no cause is shown by why he is not so, except for his descent in the slavery of his ancestors. The first section of the second article of the Constitution uses the language, a citizen of the United States at the time of the adoption of the Constitution. This question is to inquire who were citizens of the United States at the adoption of the Constitution. To determine whether there are any free persons descended from the Africans held in slavery were citizens of the United States at the time of the adoption of the Constitution, it is only necessary to know whether any such persons were citizens of either of the states under the Confederation at the time of the adoption of the Constitution. At the time of the ratification of the Articles of the Confederation, all free native-born inhabitants of the states of New Hampshire, Massachusetts, New York, New Jersey, and North Carolina, though descended from African slaves, were not only citizens of those states, but such of them had the other necessary qualifications, possessed the franchise of electors on equal terms with other citizens. It has been asserted that the Constitution was made exclusively and for the white race. It has already been shown that in 5 of the 13 original states, colored persons then possessed elective franchise and were among those whom the Constitution was ordained and established. If so, it is not true that the Constitution was made exclusively by the white race. And that it was made exclusively for the white race is, in my opinion, not only an assumption not warranted by anything in the Constitution, but contradicted by its opening declaration, and that it was ordained and established by the people of the United States for themselves and their posterity. And as for free colored persons, were the citizens of at least 5 states, and so in every sense are part of the people of the United States. They were among those whom and whose posterity the Constitution was ordained and established. It has been further objected that if free colored persons born within a particular state and made citizens of that state by the Constitution are thereby made citizens of the United States, then such persons would be entitled to all the privileges and immunities of citizens of several states. And if so, the colored person could vote and be eligible not only to federal offices, but offices even in those states whose constitution and laws disqualify colored persons from voting or being elected to office. But this position rests upon the assumption, which I deem untenable, its basis that no one can be deemed a citizen of the United States who is not entitled to enjoy all the privileges and franchises which are conferred on any citizen. This is not true under our Constitution. A naturalized citizen cannot be president of the United States, nor senator till after a lapse of 9 years, no representative till after a lapse of 7 years from his naturalization. Yet, as soon as he is naturalized, he is certainly a citizen of the United States, nor in any of his inhabitants of the District of Columbia or of the territories eligible to be a senator or representative in Congress, though they may be citizens of the United States. So, in all the states, there are numerous persons whose citizens cannot vote or cannot hold office either on account of their age or sex or the want of necessary legal qualifications. The truth is that citizenship under the Constitution is not dependent on the possession of any particular political or even of civil rights. And any attempt to so define it must lead to error. To what citizens the elective franchise shall be confided is a question to be determined by each state, in accordance with its own views of the necessities or expediencies of its condition. What civil rights shall be enjoyed by its citizens, and whether all shall enjoy the same, or how they may be gained or lost, are to be determined in the same way. Whether a person is born in the United States, be or not be a citizen, cannot depend on laws which only refer to aliens and do not affect the status of persons born in the United States. I dissent, and therefore, from that part of the opinion of the majority of the court in which it is held that a person of African descent cannot be a citizen of the United States, and I regret that I must go further and dissent both for what I deem their assumption of authority to examine the constitutionality of the Act of Congress, commonly called the Missouri Compromise Act. I do not consider to be within the scope of the judicial power of the majority of the court to pass upon any question respecting the plaintiff's citizenship in Missouri, save that raised by the plea to the jurisdiction. And I do not hold any opinion of this court or any court binding when expressed on a question not legitimately before it. The judgment of this court in that case is to be dismissed for want of jurisdiction because the plaintiff is not a citizen of Missouri. And to that judgment, according to the settled course of this court, nothing appearing after a plea to the merits can enter. A great question of constitutional law, deeply affecting the peace and welfare of this country, is not, in my opinion, a fit subject thus be reached. In my opinion, the circuit court had jurisdiction. I am obliged to consider the question whether its judgment on the merits of the case should stand or be reversed. In my opinion, the judgment of the circuit court should be reversed, and the cause remanded for a new trial.
Responses from the press. The nation has achieved a triumph. Sectionalism has been rebuked, and abolitionism has been staggered and stunned. Another supporting pillar has been added to the institutions. The assailants of the South and enemies of the Union have been driven from the foundation. The patriotic principle has been pronounced. A great national conservative union saving sentiment has been proclaimed. The Richmond Enquirer.
In the general tenor of its decisions, this august tribunal has shown itself inimical to the interests of the South and states' rights. In judgment of the Dred Scott case comes then with an exaggerated effect of surprise. Everybody in the South is disposed to unite in the course of congratulation. Certainly, it is not easy to override the importance of the principles propounded in that decision in their relation to the constitutional rights of the South. They give her claim to equality of privilege in the Confederacy, the sanction of the delivered judgment of the highest tribunal in the land. They show that in its most extreme demand, the South contends only for its rights under the Constitution. In the final conflict between slavery and abolitionism, which the very decision will precipitate rather than retire, the principles of the judgment in the Dred Scott case may be of some in the South in giving of appearance of justice and moderation to its position. The Charleston Mercury.
The decision of the Supreme Court of the United States in the Dred Scott case is the theme of bitter comment in the anti-slavery journals of the North. There's enough in it, fact, to overthrow their favorite series and upset their political plans. It clears the way for myths through which many honest men have had distorted views of the rights of the Southern people and have mistakenly lent themselves to the cause of oppression, aggression, when they suppose themselves to be merely on their defense against attack. It gives the sanction of established law and the guarantees of the Constitution, for that all the South has insisted upon in the recent struggles, and forces her adversaries to surrender their political organization against her rights, or assume openly the position of agitators of the Constitution. The New Orleans Daily Picayune.
We cherish the most ardent and confident expectation that this decision will need a proper reception from the great mass of our intelligent countrymen, that will be regarded with soberness and not passion, and it will be thereby exert a mighty influence in diffusing sound opinions and restoring harmony and fraternal concord throughout the country. The court, which has settled vexed and constitutional question as to the power of Congress over the territories, is entirely independent of the legislation of the government. It is elevated above the schemes of party politics and shielded alike from the effects of sudden passion and of popular prejudice. Little motive, therefore, can the venerable jurists who compose that tribunal have for a deviation from the true principles of the law. The Washington Union.
It is not to be expected that the abolition press would readily concur in the wisdom, justice, constitutionality, and the decision recently delivered in the Supreme Court of the United States. In the case of Scott versus Sanford, that was hardly to be supposed the journals claiming to be respectable should so forget what is due to public decency in the norm as to assert unique and deliberate judgment of the highest court of the land is entitled to no more moral weight than would be the judgment of a majority of those congregated in any Washington barroom, or to impugn with honesty and purity of the greatest constitutional lawyers who occupy the exalted position of supreme and final judges in all matters relating to the interpretation of the Constitution and laws. We believe, however, that those indecent and contemptible calamities will meet with no approved response beyond the limited circle of disappointed factions whose vocation it is to foam and strife and discord, to subserve individual and selfish ends, that by the great masses of the people who prefer truth to error, light to darkness, upon important political questions, the decisions will be respected and honored, that it will be accepted as permanent record stamped in the absolute and authenticity of the Constitution itself. The vast and comprehensive social and political importance of this lucid and convincing judgment of the first constitutional authorities in the Republic cannot be too highly estimated. It dissipates the mist in which we have been enveloped for years. It exposes all their deformity, the slavery heresies by which we have been disturbed for more than half a century. It lays down in language stripped of all sophistry and sectional bias the relations which should exist between the states and territories of the Union. It gives to the north, to the south, to the east, and to the west the true chart and compass by which to steer. And it proclaims to the people that they alone have the right, at all times and under all circumstances, to provide their own local government, to regulate their own affairs, and decide for themselves whether they will or will not adopt domestic servitude as one of their institutions. The New York Journal of Commerce.
Our Republican friends have fairly raised the standard of insurrection and are giving us a higher law in all its moods and tenses with a vengeance.
They declare in every way, shape, in every form of language, in every possible manifestation of temper, except that of reason and sense, that the decision of the Dred Scott case is not law, but that the judges who decided it don't know what law means, that their decision is absurd, nonsensical, oppressive, and tyrannical, that nobody is bound by that, nobody ought to obey it, and finally, that it shall not be submitted to. After the flurry is over, we shall respectfully request the organs, whether of party or of press, which have taken the goddess of liberty into their own as special keeping, to be pleased to let us know the platform or program upon which they propose to carry out this government after the year 1860, or whatever the millennium shall arrive, which is to induct them into power and place. If the Supreme Court is to be overthrown, and its decrees trampled underfoot.
Yet the phenomenal clauses of the Constitution are to be scoffed at and obliterated. We take it for granted that some other arbiter of controversies, some other ultimate tribunal, some other form of government, in short, is to be adopted. And we are curious to know what it is to be. What is the decision of the Dred Scott case? First, the court has decided that the government was made to secure the freedom of the white race. The people of African descent are not citizens of the United States. It is an historical absurdity to assert that the Declaration of Independence, which speaks of the freedom and equality of mankind, intended to comprehend the black race. The Declaration of Independence was made by the representatives of the communities, every one of which was slave-holding communities. If the truth could be got at, with perhaps a few exceptions, every man who signed the Declaration of Independence was at the time a slaveholder. Second, the court has decided that the property in slaves is recognized by the Constitution and that Congress has no power to prevent the citizen of one state from going into the common territory of another with property recognized as such by his state. Third, the court has decided for that a slave taken into a free state and then taken back into a slave state by his or her master, that by this act of removal, the owner does not lose the right of his property. Nobody doubts the learning of the judges of the Supreme Court. No one questions its honesty, but it is insisted with a howl of rage that they have been governed by their prejudices. Suppose they have. Do we expect the gods to come down from Mount Olympus to govern us? As long as the short of it is that the so-called Republican Party is only another name for the revolution and anarchy, it is fundamental notion. It is a derision of all the law that does not suit its whim. The New York Journal of Commerce.
Such then is the end of the great commotion about the Nebraska bill and the Missouri Compromise. The highest judicial tribunal in the land has declared that it was unconstitutional and void. In place of avoiding unconstitutional enactment, we have established upon a basis of the broad and salutary principle of popular sovereignty for the states and territories. Local questions are to be settled by local residents. That is the democratic doctrine. It is approved, affirmed, and established beyond recall. The Pittsburgh Post.
The cardinal points of the Supreme Court's decision are reported as follows. 1, the Negro, because of his color, is denied the rights of a citizen of the United States and even the right to sue in our courts for the redress of most flagrant wrongs. 2, a slave being taken by his master into a free state and thence returning under his master's sway is not therefore entitled to his freedom. 3, Congress has no rightful power to break slavery in the territories. Hence, the Missouri restriction was unconstitutional. The judgment annihilates all compromises, brings us face to face with the great issue in the right shape. Slavery implies slave laws. That is, law sustaining and enforcing the claim of one man to own and sell another. The New York Tribune.
The decision of the Supreme Court in the case of Dred Scott completes the nationalization of slavery. Slavery is no longer a local institution, the creature of a local law, dependent for its existence and protection upon state sovereignty and state legislation. It is incorporated into the Constitution of the United States. Its tenure is the tenure of all property, and the Constitution protects and preserves it to the same extent upon the same principles as it protects any other property of any kind whatsoever. Slavery is no longer local, it's national. The New York Daily Times.
The dangers apprehended from the organic tendencies of the Supreme Court to engross the legislative power of the federal government, which Jefferson foresaw and so often warned his countrymen against, are no longer imaginary. They are upon us. The decision rendered by that body has struck at the very roots of past legislative policy of this country in reference to slavery. It has changed the very blood of the Constitution from which we derive our political existence. And it has given to our government a direction and a purpose as novel as it is barbarous and humiliating. The New York Evening Post.
In this horrible handbook of tyranny, it is asserted first that according to the past century of opinion adopted as law in the Constitution, black men have no rights which white men ought to respect, but may be reduced to slavery, bought and sold, and treated as ordinary articles of merchandise. Second, that the Negro race are excluded from the Constitution, from the possibility of being citizens, and from having any personal rights and benefits. Third, they are articles of merchandise. Fourth, their being free makes no difference, for the Constitution treats and considers them as mere property and gives the government power over them as such. These assertions the judge attempts to sustain by deliberate falsification of the Constitution and of history. If they were true, then the Constitution would be a document reprimanded by an Almighty and entitled only to the curses of mankind. The New York Independent.
The truth is, the court has been wholly revolutionized. This sleepless vengeance of slave power has been constantly watching its opportunity to invade the temple of justice from time to time, insisting upon the appointment of advocates of its most obnoxious doctrines. Until now, the tribunal is apparently its own, ready to sustain the most ultra-southern ground. The Salem Register.
What do we do? Should we rebel? We answer no. It would be idle and useless. In a government, it seems very necessary to have a court remove some distance from immediate popular influence to control even the executives. The Supreme Court has made many righteous decisions. It now makes one horribly wicked. We ought to oppose and expose the decision. The several states must, as far as possible, nullify it. We ought to prepare for the crisis that is coming. The oligarchs, artists of slavery, are waxing bolder and bolder and more insulting. There are now no free men in the North. Soon they will see that our free labor interferes with their progress. The next step now will be probably to be the purchase of Cuba, after which, without any special act, the foreign slave trade with Africa will be open. The Boston Wesleyan Journal.
Chief Justice Tenney defines what it means to be a person whose ancestors were imported and sold as slaves. Upon this definition, he proceeded to build his decision. But the persons who are part white, mulattoes, not citizens? How is it with those whose ancestors immigrated to this country from Europe? And how is it with that large class whose veins of blood of the whites preponderate? How much white blood is necessary to make a Native American a citizen? The Chicago Tribune.
Frederick Douglass. We are now told in tones of lofty exultation that the day is lost, all lost, and that we might as well give up the struggle. The highest authority has spoken. The voice of the Supreme Court has gone out over the troubled waves of the national conscience. saying, "Peace, be still." This infamous decision of the slaveholding wing of the Supreme Court maintains that slaves are within the contemplation of the Constitution of the United States property. That slaves are property in the same sense of horses, sheep, and swine. You will readily ask me how I am affected by the devilish decision, this judicial incarnation of wolfishness. My answer is, and no, thanks to the slaveholding wing of the Supreme Court. My hopes are never brighter than now. I have no fear that the national conscience will be put to sleep by such an open, glaring, and scandalous tissue of lies that the decision is, and has been, over and over shown to be. The Supreme Court of the United States is not the only power in the world. It is very great, but the Supreme Court of the Almighty is greater. Judge Taylor can do many things, but he cannot perform impossibilities. He cannot bail out the ocean like this from old earth, or pluck the silver star of liberty from the northern sky. He may decide and decide again, but he cannot reverse the decision of the Most High. He cannot change the essential nature of things, making evil good and good evil. Happily for the whole family, human family, their rights have been defined, declared, and decided in the court higher than the Supreme Court. Your fathers have said that man's right to liberty is self-evident. There is no need of argument to make it clear. The voices of nature, of conscience, of reason, of revelation proclaim it is as a right of all rights, the foundation of all trust, and of all responsibility. Man was born with it. It was his before he comprehended it. Such a decision cannot stand. God will be true, though every man may be a liar. We can appeal from this hell, black judgment of the Supreme Court, to the court of common sense and common humanity. We can appeal from man to God. If there is no justice on earth, there is yet justice in heaven. You may close your Supreme Court against the black man's cry for justice, but you cannot, thank God, close against him the ear of a sympathizing word. Nor shut up the court of heaven. All that is merciful and just on earth and heaven will execrate and despise the edict of tyranny.
Notice, shortly after the Supreme Court decision, the sons of Dred Scott's first owner, Peter Blow, purchased Scott and his family. The Blow brothers then freed the Scotts. Thus, the negative results of the case were in fact short-lived. Dred Scott remained a free man and something of a celebrity from May 26, 1857, until his death 9 months later on February 17, 1858. Justice Taney died on October 12, 1864, before the nation synthetically rejected his judicial handiwork. His decision had put in motion forces that ended the controversy over slavery in the territories, but not in the way he wanted.